He is misleading you, sir.
Honourable, there's no point of order, please.
Am I allowed to explain?
Honourable, there's no
All right.
point of order. There's none.
Mr. Speaker, this debate has seen us being visited with some interesting perspectives from the Leader of the Opposition. They tell me, though, that he doesn't only not know his history, he doesn't know his political history, he doesn't know his legislative history, and he really doesn't understand the context of what is happening and what brings us here. But instead, he finds it convenient to palaver about roads and tint and a host of other things, some ills, some ill-advised, but nothing really that deals with what is before the chamber. Mr. Speaker, in 1992, this country was governed by the party that he now leads. In 1992, his party came to Parliament and amended the Road Traffic Act so as to provide for the very thing that he now says is unconstitutional. His party passed the amendment to the Road Traffic Act to provide for fixed penalties. They left government in '94, came back in 2008, didn't touch it, and left again in 2018. But the honourable member says, this is so simple. This is so simple. They enacted it, completed the term without bringing it into place, occupied the halls of government of this country for a decade, did nothing with it. But now the honourable member wants to chastise this administration when we are finally bringing into fruition something that his administration did. You should be thanking us, sir. You should be thanking us. But with all the simplicity that it contains, it tells me that he has not even troubled to look at where the amendments are coming. You see, he hasn't even touched the bill. He used the word road traffic on many occasions, but on no occasion did in any of the paragraphs, long, rambling, and winding that he treated us to, did he condescend in any way on the legislative provisions that we have brought to Parliament. But in another place, sir, they will call that co-swiping. And it is the season for you to remember to co-swipe, just like he did yesterday in his press conference. Mr. Speaker, what do we have here and why are we here? Section 121.10 of the bill, of the Act, let me talk about the Act, of the Act, provides for the maximum, provides the regime for the penalties. It tells you, and I'll read it for the chamber. It tells you, sir, what is the amount that the penalty can be. It says, sir, the fixed penalty referred to in this section is one of the following: $50, half of the maximum fine to which a person not previously convicted is liable on summary conviction of that offense, whichever is the less, or such fine as the minister prescribes, not exceeding one-half the maximum amount of the fine to which a person previously convicted is liable on summary conviction. So you have, say, the $50, half of the fine if you've never been convicted, and half of the fine if you had been convicted. Now, Mr. Speaker, when we began to work on the fixed penalty regime, we immediately recognized that a regime of fines established in 1992, in many cases as far back as 1984, when the bill was first passed, sir. And you know, 84, that's how long ago? 39 years now? Almost 40 years. The level of the fine set in law at that time would hardly make sense in today's environment, sir. That is why you're dealing with $50. The extent of a $50 penalty in 1984, or put another way, perhaps in economic terms, what you could buy with $50 in 1984 is very, very, very different to what you could buy with $50 today. And that is why across the criminal regime, whenever we have come to Parliament to make amendments to legislation, we have looked at what fine existed and what would be a comparable fine in today's age. No one would argue, sir, that a fine set out in law in 1984 could be reasonable today. In 1984, you could probably have bought a snow cone for 20 cents in the bus stand. 20 cents. In 1984, bus fare was probably 25 cents a ride. In law, sir, we talk, and in economics, I believe we talk about the present day value of money. So that as we look at compensation matters, we look at what it is that the court would have awarded 30 or 40 years ago, and what would be an equivalent amount today. $50 40 years ago has to be increased so as to be commensurate with today's values. And therefore, recognizing that with a fixed penalty regime, a person is going to be invited to just pay the penalty and move along without going to court, we had to make sure, sir, of several things. One, that the amount of the penalty would have to be such that it would be an incentive for the person not to go through a court process, but it still had to bear in mind the realities of the current value of money. And therefore, it was obvious to us that we needed to amend Section 121.10. Otherwise, our fixed penalty regime would have such low penalties that a person could break the traffic laws as they pleased and just pay the penalty. So the first thing we had to fix was what are the things that would allow us to have a sensible penalty regime which can allow the minister to establish what the penalties are, but that they not be linked to penalties that would have been established 40 years ago. That's the first thing. And for that reason, we therefore had to bring this amendment so as to allow the minister to impose sensible penalties. The second thing that we had to do was to allow the minister to be able to determine what are the offenses that the regime would relate to. We had a whole set of offenses, we have it in the existing legislation, but the truth is offenses have fallen off the books or will fall off the books. Other offenses will come in as time goes by, and therefore it was important, rather than listing offenses, to be able to give the minister the power to say, well, these are the offenses that we'll be applying fixed penalty regime stuff. Now, throughout it, Mr. Speaker, I really don't get the sense that the Honourable Member, the Leader of the Opposition, had any burning animus against the fixed penalty regime. He could not, because as I pointed out to the Chamber, it was his party that brought it into place. But, well, I thought I was going to begin my speech by saying, I want to begin where the Honourable Member left off, but he was leaving off on so many occasions that he left off about 4 or 5 points ago, the matter of the constitutionality. Now, I don't want to be disrespectful. It isn't in my nature. I wasn't brought up that way. From the time the Honourable Member took that seat there, he has found every occasion in the book, every reason in the book, to pontificate about constitutionality of this and the constitutionality of that, and everything this government is doing is unconstitutional, and we are breaking the Constitution. You know, Mr. Speaker, it would behoove an eminent counsel, if he was so convinced of the unconstitutionality of the various laws that we pass and the steps that we take, to put his money where his mouth
Point
is.
of order, sir.
Point of order, sir. Point of order, sir.
The honourable member is misleading the House. I was listening and trying to count the number of occasions on which I have challenged any legislation on the basis of its constitutionality. And if I start counting, it would not be more than 4 pieces of legislation, so that the public would not, and you, sir, would not want the honourable member to mislead you in saying that I have challenged every piece of legislation as to its constitutionality. That is simply not true. He is deliberately misleading you, sir.
Honourable,
Thank you, sir.
Continue, Honourable.
The honourable member loves to count. He's been counting in here all morning. Happily, when it comes to the opposition, there's only one number that matters. 0. That of no value. If the honourable member says it is 4 occasions that he has challenged the constitutionality in this chamber, I want to ask him, and how many times have you challenged it in the court? You see, that's the point, you know, Mr. Speaker. There's some of us in here who have practiced law, our only profession is law. The honourable member lives in the court. And if he's so convinced that the bills that we have passed are unconstitutional, why has he not used the skills that he has?
Point of order, sir. The honourable member knows that you challenge the legislation only when he has one too.
No, I want to hear the point of order. I want to hear it. No, Honourable, you speaking to the chamber here. I want to hear the point of order.
No, I was wondering if
You're not
I was
referring
wondering
to...
if he's going to apologize
Honourable
for
members,
demoting prison officers and fire officers. But
Honourable-
let me speak, sir.
Honourable, please speak to order. I will ask you to say it. If you repeat that, I will ask you to say it. You can make no reference to any point of order and anything to do with prison officers. I will not allow it in
And
this
fire
chamber.
officers, sir.
But I'm fire officers.
Yeah, let's not deal with
Speak
those
or I
today.
will ask you to sit down.
Yes.
I'm listening to you,
The
sir.
honourable member knows, as a lawyer, and he's a senior lawyer, that you don't have legislation passed here and run across by the court the next day. He knows that. So let him, I know he's not misleading you
He's not Honourable,
precisely, but he's misleading the public.
Honourable member, you have no point of order.
Well, the honourable member wants to contain that he's able to say in here that the laws we pass are unconstitutional, but that it suits him not to challenge it. That is his business, sir. We are satisfied with the constitutionality of the laws we pass, and in this instance, it is a red herring. And he ought to be ashamed, because if it is unconstitutional, no, it was unconstitutional when his government passed it. And the fact is, Mr. Speaker, that we have now, you know, I don't like schooling him because I feel he had a little hard. You see, Mr. Speaker, he is misunderstanding the unconstitutionality of a mandatory minimum penalty, which you know quite well. The courts have long determined that a mandatory minimum penalty is a penalty that removes the discretion of a judge, and therefore, for that reason, it is unconstitutional. But that is to be completely distinguished from an administrative monetary penalty, which is what we deal with here, which is what his administration passed into the law back in 1992, which is what the traffic wardens have been doing every day up and down Bridgetown when people park in the wrong place. The traffic warden serve you with a penalty. They give you a notice, a mandatory penalty. So we have been using mandatory penalties now for a long time. Moreover, sir, we have put mandatory penalties in place in relation to possession of cannabis. We put mandatory penalties in place
Honourable, start interrupting, please.
in relation to the market. We have said from the time we came to government in 2018 that we considered one of our missions to be to prevent the unnecessary criminalization of Barbadians. People commit traffic offenses every day, but they don't do it because they're villains. An individual hurrying to get to some place, speeding. An individual whose brake lights might not be working. Mr. Speaker, I don't know if my brake lights are working or not. Do you know when yours are working, sir? Probably not. You don't know. I don't believe the honourable member. I hardly think that the honourable member, leader of the opposition, gets in his car and tells somebody, go and stand behind my car while I press the brake. I don't think he does that, because he would accidentally run them over. He wouldn't do something like that. So the point is that traffic offenses are of a kind that do not generally carry the animus, the mens rea of a person intending to commit an offense. Sometimes they do, but for the most part, they don't. And we have always felt that we should not criminalize Barbadians, give them a criminal record, have them to go into court and be found to be guilty of committing one offense or another in circumstances where administrative penalties could fit the bill. And what is that bill, sir? You don't get a criminal record against you. You don't have to take your time and hire a lawyer to go to court. Now, very often, sir, and I know that, eminent counsellor, you don't do traffic matters. But sometimes, you know, sir, in our younger days, when we used to do them, you might charge a man $500, and you go to court, and the magistrate put a $300 fine on him. And the truth is, he would have probably get a $300 fine if he'd gone and plead guilty just himself. Okay? So you don't now incur the cost of paying a lawyer to go and defend the matter. When a policeman charges you with a criminal offense, let's work through it. He has to prepare the statements. A summons has to be prepared. The summons then has to be served on the defendant, who now comes to court. And who, if he pleads guilty, if he pleads not guilty, will have to come to court repeatedly, sometimes for years. Now, a citizen X, when faced with the choice of being told, listen, we consider you have breached the law. Your brake light is broken. It isn't working. You're driving without insurance. There are any number of things that are objectively proven, but that people go to court and plead not guilty simply because they're hoping for the best. It is a far better arrangement just to say, this is the penalty, go and pay it, and move along. Most people, I think most rational people, would adopt that approach. They know, mea culpa, I'm guilty, mea culpa. They'll go, pay the fine, and move along, without using up the police officer's time, without using up the court system's time. Those are the reasons why all across the world, administrative monetary penalties are imposed on individuals. The honourable member wants to drag a red herring across this proverbial trail by saying that the government wants to punish people. Penalty. They're imposing a penalty because they want to punish people. Mr. Speaker, that is so empty and absurd. You know, I've said I want to be respectful. In law, in the Road Traffic Act, an offense is created. It is called an offense, whatever it is. And the law says that if found guilty, you shall be liable to a particular fine. And the magistrate, as you well know, sir, can impose from a low fine to a high fine. In some instances, you may even find yourself subject to imprisonment. Now, we are saying, let us move all of that one side and have a simple system of administrative penalties to replace a penalty imposed by a magistrate that you might catch in a bad mood a particular morning. Because when he was driving up to Horse Hill Court, some vagabond driving a red Toyota passed you out in Blackman's Corner and almost rate you off. And by the time he get court, he vexed with everybody in the world. And anybody at all that got a traffic matter. And I just said, district head, but it could be any court. There's somebody here who will well understand not just the sociology of law, but the sociology of I remember one of my lecturers who used to say, you know, if you get a judge in a bad mood, the wife ain't cooking the breakfast for you, the children make you late, the dog dead, whatever. He listened to, remember for St. Michael's South, sorry for Christian South on the radio, a number of things. You do not know how that judge will rule when he gets there. So you're opening up yourself to a $100 fine or $2,000 fine. Those are the realities. I think they call that the School of American Realism. So all we are saying is, let us put a system in place. You know what it is predictable, there's no emotionalism attached to it, there's no risk of a judge being in a bad mood. You go and you go and pay the fine, and you do it online, and you have paid your debt literally to society. How much more convenient is that? What is the penalty that the honourable member is talking about that suggests that we are being rapacious? No, sir. We are, in fact, removing a lot of the inconvenience, a lot of the hardship from what currently exists. Now, if the honourable member was saying that we are putting a penalty in place where there was never any penalty, perhaps you could understand. Perhaps you could understand. But we are moving from a system which says you can be liable to $3,000 or 2 years imprisonment and saying instead, pay $500. Pay $500 to your treasury. Does that appear, sir, to be a government that is looking to punish people? Where's the punishment? Surely, the honourable member, having passed the administrative penalty arrangements in 1992, is not now saying that we should resile from the position that his party touted and keep what currently exists. I don't believe he's saying that. But he's arguing out of both sides of his mouth. Because on the one hand, he says, it is so simple to fix. We should do it ever since. But on the other hand, he's saying, but it's unconstitutional. But when they're trying to frighten the Bajans, when they're trying to mask the public to pay fines, but that's what the magistrate does when he rules. Hey, I will give many more than you. I will give many more than you. And I have given many more than you in the last 8 years. Mr. Speaker, the advantages to what we're proposing, we think are obvious. But if the honourable member feels that this is driven purely by the position of the executive, he'd be mistaken. Because the entire judiciary, both high court and lower court, have been asking us, wherever possible, remove certain offenses from having to go before the judicial system. The Chief Justice has met, we have a committee called the Judicial, the Criminal Justice Reform Committee. We have a committee chaired by the Chief Justice called the Criminal Justice Reform Committee. It is one of the recommendations of the Needham's Point Declaration. made a document of this house. The honorable member doesn't like to read the things that are in this house. If only he would know so much more. And that Criminal Justice Reform Committee, not foolishness, that committee has been working with us to try to get cases out of the judicial system. Out of the judicial system. The leader of the opposition.
Honourable, please.
The leader of the opposition wants to appear blind to the facts. But if he were truthful with himself, he will know that in our traffic court, and we don't have a traffic court other than in District A, but we say that the traffic court is sitting wherever it is, he would know that there's a tremendous backlog of cases to be done. And every time the police charge, we've stopped the police from going to traffic events, going to traffic accidents. You know what we're talking about. We've removed from them the burden of going to almost 6,000 fender benders every year so that they can more effectively do policing. Whenever the police go to a fender bender, the first thing they do is warn you, and the Road Traffic Act, you may be prosecuted. That process has gone through the window. We're trying to make the work of police officers more efficient, remove unnecessary things for them. Every single time that a police officer has to show up at District A or District F or he stands for a traffic offense, it means that chances are he's worked the night before and not got to go there to deal with traffic offenses. We're getting those things out of the system. Now, the honourable member is free to disavow the traditions on which he now stands, but he cannot remove the fact that the Democratic Labour Party is who put this in place in 1982. So tell us what his position is. Is he for it, or is he against it? Is he for it, or is he against it? I was saying that I can't sense any burning hatred for it, but more and more I'm beginning to feel that the honourable member is disavowing the rich traditions of the party that he now leads. That is why he put people out of George Street. Mr. Speaker, this matter should not attract too much attention in this chamber. It is a small amendment, but a necessary amendment. When the penalties are determined, the Deputy Prime Minister and the Minister for Public Works has indicated that it will shortly go before Cabinet. They will be laid in Parliament and under the Act as we're amending by way of negative resolution, so they will come here. But we're asking Barbadians, and it will receive all the necessary publicity so people will know. But this is a step in the right direction, a step whose time has come. But when one wonders why it wasn't done by the party that put it in place in the last decade, you don't have to wonder about us now, because we are doing it. The Chief Justice has asked respectfully, can you please take these matters out of the magistrates' court so that our magistrates can focus on delivering justice between individuals. That is the key for the work of the magistracy, and not trying to deal with this body speeding, that body ain't got a brake light, that body wasn't wearing the seatbelt, those kinds of things. They do not require a magistrate's time. They don't require a police prosecutor's time. They don't require police officers to come and give evidence, sir. So this is about efficiency. And yes, you'll be able to pay your fines online. So you can sit down in the convenience of your own home without having to go to a particular court and do these things. We've put an entire online platform so that people can make payments that are due to the state online. Mr. Speaker, I don't know that I really need to add anything else. I think that this ticketing system is one that I don't mind the origins. I don't mind that it was a DLP initiative. I don't mind it at all. There are some things that the DLP has done that this administration is happy to see through. Happy to see through, except in relation to the Honourable Member for Christchurch South. We might prefer to see him out rather than rather than through. So, Mr. Speaker, I support this bill. I believe that it will address some fundamental needs of our criminal justice system. It will bring transparency to our process. It will bring certainty. And most importantly, it will bring convenience and ease of doing things to the Barbadian public who are affected by it. As I said, sir, most of the criminal offenses are not committed by people who are knowingly engaged in criminal activity. Even the slowest driver among us someday might just find themselves over the speed limit. Things like this happen. And we don't want to be criminalizing people and having a criminal record which says you are guilty. We want to remove that from the system. Some of us may drive when we travel overseas, and we may commit traffic offenses. You get a summons, you go and pay the thing with your credit card, and it is the end of that. That is the direction that we're going in, and I support it fully, sir.
Honourable member for St. Michael's Southeast.
Mr. Speaker, I beg to move the suspension of the House until 2:15 p.m., please.
The question is that this honourable chamber be suspended until 2:15 p.m. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it. This honourable chamber stands suspended until 2:15 p.m.